extrapolate it in such a way that you come up with something totally different, then obviously the comment cannot be said to be fair. Now, of course, I'm putting it in overly simplistic terms. It's not a mathematical game. It's not possible to say 1 plus 2 equals to 3. Some people have different ways of thinking about things, and hence creativity and so on. So, what is a fair comment? This is sometimes problematic, and it is on the party advancing the defense to show that my comment is a fair one. Based on the following circumstances, this is a fair conclusion to make. Okay, you may not agree with it, but this is my conclusion. This defense gives us room for opinions, because otherwise, other than the truth, right, then we have no opinions, and there are many things we do not know the absolute truth of. We will sometimes never know. We can only speculate, we can only guess, but you know, there are such things as intelligent guesses, and there are things sometimes you make wild guesses, right? Then where absolute privilege is accorded, there are certain things where there is absolute privilege. Utterances made in Parliament are absolutely privileged. Okay, same thing with proceedings in the courtroom. So the lawyer can go and call you all the horrible names. Good luck, you're not going to be able to sue him outside the courtroom because it's totally privileged. Right? This is to ensure that you can have the greatest latitude and freedom of exchange in these circumstances. Right? Then you have qualified privilege. Qualified privilege is slightly different from absolute in the sense that it relates to individuals. So if and qualified privilege has to do with two parts: the right of the person to give the information and the right of the receiver to receive it. In other words, if it's in my interest to know, then I cannot then sue you because, right, it may have been false, right? For example, if I'm going to invest in a company, right, and one of the shareholders comes up to me, maybe with a false statement about the company's management, right, and he says, well, you know, this is what's going on, that person cannot be sued for defamation, even if it was by the company itself, by publishing it only to me, because I have a right to know. Now, of course, if I choose to believe it, that's another story. But you're publishing it not to the whole world at large, but to somebody who has a right to know. So this qualified privilege thing, it becomes sometimes quite tricky. Now, in the UK, for example, they have widened qualified privilege to include press. And so the press has got certain kinds of qualified privilege. One of the big debates in the UK now about this area of qualified privilege, or in fact the big debate has shifted now to Singapore, because the Court of Appeal actually is hearing a case right now relating to the Far Eastern Economic Review, right? On whether or not we should have this public interest exception. And what is the exception all about? It is based on the idea of responsible journalism. If I have done all my homework, I have checked all the sources, and I believe this to be the case, I go to press. Now, I think many of you are from the press previously or connected to the press, you know that you have to meet your deadlines, and you can only do your best up to a point, right? And the story goes out. And it turns out, unfortunately, if the story is wrong, right, and it succeeds in, and therefore defames a particular person or company or something like that. Now, the qualified privilege under a rule in a famous case called Reynolds is that if you have done your homework and they've given something like 30 rules of things that you must do, right, you should be doing, then you are exonerated from any accusation of defamation on the basis of qualified privilege, in that you as a newspaper have a duty to communicate important news to the world. The reader has a corresponding right to receive information about a certain matter, right? And so on that basis, you can have a qualified privilege. Very contested. Right now, we do not recognize this qualified privilege although I'm told by the lawyer who is arguing the case before the Court of Appeal right now, that the court was adjourned for 2 weeks for both the lawyers to make submissions on whether or not the exception in Reynolds should extend to Singapore. And I think this is quite exciting. I mean, for us, it's always exciting. Right? We can't manufacture these things every year. And of course, another defense is unintentional defamation under Section 7 of the Defamation Act. Okay? If it was not intentional, you were innocent all along, it was inadvertent. So long as you have made apologies, you are exonerated. Now the next thing that might get you into some kind of problem is contempt of court, right? There are 2 types of contempt of court, right? The phrase is used broadly. What we might call contempt by interference and contempt by disobedience. Contempt by disobedience doesn't concern us. This is where the court issues you an order and you fail to comply, right? Like if the court has ordered you to stop doing certain things, or the court has ordered you to pay your ex-wife maintenance and you don't pay, that is contempt. In other words, the court has given an order, you have refused to obey. Nothing to do with us. What we are concerned with, as far as media is concerned, is contempt by interference. And the contempt by interference can take place in 2 ways. The first way is what we might call sub judice. That means a case is pending before the court now and you start commenting on it, hoping to sway the court one way or the other. This is not allowed because the idea is that justice has got to be done, right, free from external interference. So if the press starts lobbying, okay, now there have, I think, in history been instances where quite clearly the press reports things in such a slanted manner. Singapore, less so, but in some other countries you can see, right, that this happens. Technically, you can be hauled up for contempt of court, okay, under the sub judice. Then again, you know, I can't imagine too many bloggers doing too much of that kind of advocacy, you know, taking up cases and arguing, unless you know, it is right up your alley on that point. Now the other one, which gets a lot of bloggers into trouble, is a direct attack upon the court itself. Right? If you start saying that the court is unfair, it's not independent, it's an adjunct of the executive, it's taking instruction, the marionettes manipulated by, you know, the government. I mean, if you start saying things like that, I guarantee you, you will be hauled up for contempt, right? Now, therefore, now what is then the basis for the contempt? The leading statement of it is a case in AG and Times newspaper, where it said that the law of contempt is founded entirely on public policy. In other words, it is not based on any other rationale. It is not there to protect the private rights of the parties to the litigation or the prosecution. It is there to prevent interference with administration of justice, and it should be limited to what is reasonably necessary for that purpose. In the case of the Attorney General and Daniel Hertzberg, who until recently I think was the Deputy Editor-in-Chief of Wall Street Journal, the court stated that the rationale for the law of contempt is rooted firmly in the public interest, in that it aims to protect the administration of justice as well as public confidence in it, which is crucial for the rule of law and the maintenance of law and order in any civilized society. It is not in any way intended to protect the dignity of the courts or the judges. So here they're talking about, it's not so much whether you attack the judge or the court, but by saying things about the judiciary by and large, that may demean it, that may actually cause people to lose confidence in its ability to mete out justice and administer justice. That is where you have a problem. Now, you can be punished for contempt under both the Subordinate Courts Act as well as under the High Court, the Supreme Court of Judicature Act. Several cases where you had contentious behavior take place one of the earliest cases in Singapore is a case of the Attorney General against Pang Cheng Lian. The name may be familiar to some.